make a decision, I'm going to throw your stuff out because you don't know what you're doing. Bottom line.
Okay.
So, either I got to start taking over your case, which I can't do, or you're going to lose because you don't have a clue what you're doing.
Accountable. If it's
okay, ma'am, what you want is not real important to the discussion today. Is there a legal reason that he'd do something wrong individually that makes him individually be liable? All right, looks like Ms. Giller is connected. Counsel, your appearance for the defendant.
Good morning, Your Honor. Brian Gerda, P8056, on behalf of the defendant's counter plaintiffs.
All right. So, counsel, what do we got scheduled today?
This is our motion for summary disposition, C8, C9, and C10.
Right. Okay. Yeah, I looked at this last week. Ms. Giller, did you get a copy of that paperwork that was filed with the court by the counter plaintiff defendant?
Yes.
All right. Just confirming, did you submit a written request or excuse me, a written response?
Yes, I did.
Okay, that's that really big stack of documents with no explanation to it? Correct?
Yes, I'm sorry. Yes,
Okay.
that's correct.
All right, well, that puts me in a really awkward situation because I've got over an inch thick stack of documents. I'm not going to go through this stack of documents, try to figure out what I think they mean to you.
Okay.
So, when you file a written response to a motion, usually you explain your argument, you explain what each one of your exhibits means, so on and so forth.
That's okay.
So I'm inclined to give you two options. Number one, you can try to do that orally today, or number two, I'll give you another date so you can submit more paperwork that explains what all these documents are supposed to mean to me.
It's very simple. I just wanted to show pictures.
Okay.
Basically, from the beginning, the first exhibit is the advertised Cordell house. When I originally looked at the house, you can see the damage. I zoomed in on where in the kitchen the damage was coming from. I had a water leak that was coming down from the kitchen. And you can clearly see it. He was talking about new appliances. I have pictures to show in there that there was not. The piping, I had an open sewage line, 2 of them that were not capped in the kitchen. I paid for things he was supposed to pay for. I paid for 3 trees to be removed in the back of the house.
Okay, let me interrupt you just for a minute, because I think what you're doing is telling me about all the support you have for your case against the defendants.
Yeah.
Okay, that's not what we're discussing today. What's scheduled for today is the motion that's been filed on behalf of Punjab Investments and Mr. Singh for summary disposition, which basically says your case against them should be dismissed. Did you understand? Did you read the motion?
Yeah, so I thought that's what I was doing. I submitted the pictures, the city documentation showing his default.
Well, all right, let's start with I think what I think will be the low-hanging fruit. One of the things, and counsel, if I misspeak about your position, would you please correct me?
Yes, sir.
One of the low-hanging fruit out of that motion, I think, is that Mr. Singh individually should not be part of this lawsuit because you did not do business with Mr. Singh. Counsel, is that a fair summary?
Yes, Your Honor.
Okay, so let's talk about that first, Ms. Giller. Why should Mr. Singh be sued individually if you did business only with Punjab Investments?
I put both names because he was the primary person that I was going through. So I put both names. I put Punjab Investments as well as Guri.
Okay, but would you agree with me that if you go to buy a GM car from a dealership and the car is faulty and you sue GM, you don't sue a GM shareholder just because they happen to own some stock?
Right. Well, I did add his company name onto Punjab Investments is listed on the documents.
No, and I understand that you did business with Punjab Investments, which is a separate legal entity from Mr. Singh. Would you agree with me there?
Well, he's the owner of it, right?
Well, he may be, but that doesn't make him the same as the company.
Okay, so they're two separate.
They're two separate legal entities.
Okay, so by me putting both names on the case, though, it still holds him liable for his company, right?
That's what we're trying to determine today. Why should he be liable if you did business with his company and he was just a representative of the company?
I want to be able to hold him accountable. I mean,
Okay, but you have to give me a legal reason why he is accountable. If you sue Kroger because you went to buy groceries and you fell and hurt yourself and you dealt with a cashier, would you sue the cashier because she worked for Kroger?
No.
Okay, that's the same situation here from a legal standpoint, unless you've got some reason why Mr. Singh is individually liable when, from what I've seen, all he did was represent Punjab Investments in the company's dealings with you. Follow me?
Yeah, I do.
I'm not saying that the company might not be liable to you.
Right.
But at this point, I want to talk about the attorney's argument that Mr. Singh individually is not liable.
Okay, he was the individual that I was personally dealing with. I put both because I want him to be able to be held accountable. If it's
okay, ma'am, what you want is not real important to the discussion today. Is there a legal reason that he do something wrong individually that makes him individually be liable? Or did he just represent Punjab Investments when you dealt with the company?
He was representing his company.
Okay. All right. Is there any other reason you thought you should put his name on the paperwork?
I put it on because he was the main person that I was dealing with.
Okay.
I mean, the legal.
So he was your contact.
Yes.
I understand that. Okay. But that alone does not make him individually liable for any damages you suffer from Punjab Investments. Understood?
Correct.
Okay. All right. So counsel, as to Mr. Singh, the motion's granted, he's out.
Thank you, Your Honor.
All right. So counsel, go pick up from there and hit the high points of the balance of your motion.
Yes, thank you, Your Honor. I just want to highlight a couple troubling procedural deficiencies from the plaintiff's case here. No response has been received at our office to this motion for summary disposition that we filed. We are working with a small claims complaint in this case that's very vague, ambiguous, doesn't really state any cause of action. In fact, the only things listed on there are items that were caused by Ms. Giller herself while she occupied the property and didn't report any deficiencies in the condition to the landlord, Punjab Investments. All that said, we just don't have much in the way of pleadings to respond to, but I hope our motion brings everything to light into what's really going on here. This is a case brought with vexatious intent, vindictive intent, because my client issued a notice to quit and proceeded with summary proceeding action to evict Ms. Giller. And on our Exhibit 3, we attached a demand for possession. And the explanation there was failing to report a leak in a timely fashion, causing extensive damage to kitchen, mold, destruction of property. And this is a common theme here. Ms. Giller resided at the property, she leased it, and would not report or make maintenance requests for things that need to be done, such as this leak that occurred in a timely fashion.
Sorry to interrupt, but how long was she in residence?
She, let's see, began on September 7, 2018. We've gone through August 2019. I don't have any extensions in my file, so I imagine she was month to month after that. And then the notice to quit was sent at October 23, 2019.
So October 23 is when you sent the notice, and she moved in when?
She would have moved in on or around September 7, 2018.
All right, so roughly a year plus. Okay, go ahead.
Correct. So with her, and we attached a list, and there was exhibits 4 to our motion for summary disposition. As to the exorbitant amount of damages my client had to incur in completely fixing all the wreckage that Ms. Giller left behind. We don't know why all this happened. Could have been mere negligence, could have just been a lack of care for another individual's property, but the reasoning is ultimately irrelevant. The fact is that all this damage was done when my client gave her the property without all this damage at the start of their lease. And none of this is what we call normal wear and tear. A tenant is excused from being charged for anything that is considered normal wear and tear. And all this is absolutely excessive and abnormal, uncommon sort of damage that a property owner finds in their property. The bill there is $15,225 to repair what had to be done. In addition, she did not pay 2 months of rent, and that's sitting out on her ledger, so we're also seeking that amount. So any of the claims, it's two ways. We got counterclaims here. So any of the claims brought by the plaintiff, she's not able to justify or point to any legal cause of action. As I mentioned, she's simply citing to things that she did at the property. You can't tear down a wall, wait a year, and then blame the landlord for you not having a wall. If it's something that happens in the ordinary course of living somewhere, you need to report it. You need to make a maintenance request. If there is something such as a leak, you need to report it to a landlord. Failure to do so that causes damage to the property is the fault of the tenant. And just like the other damages that we have here. So in summation, she hasn't stated a legally cognizable claim. And there's no evidence provided either in response to our motion or attached to a complaint or an amended complaint for us to work with here to even see what, if anything, supports her allegations. On the flip side, we have documentary support in support of our claims for damages in response, and Ms. Giller has not provided anything to refute that. So I am requesting that this time, and this motion has been scheduled for months now, that the court dismiss her complaint in its entirety as to the remaining defendants, the LLC, and award judgment in favor of Punjab to recover from the damages it sustained of Ms. Giller's tenancy.
All right. The last time I saw parties on this matter was back in May of, man, my date stamp was bad. It looks like May of last year. And we discussed the fact that the parties were going to go to Wayne County Neighborhood Dispute Resolution. Did that happen?
No.
Why not?
I never heard anything. I waited to hear something back from them.
I believe there's a lot more to that story.
Well, I'm giving you a chance to tell me.
Yep, I didn't want to interrupt her. So, Mr. Horka from our office, and I believe there was one appearance in between May, because I was here back in May, where it was said that she hadn't received a copy of our motion for summary disposition.
Yeah, you know what?
At that hearing, I remember.
It looks like we were briefly on the record November 24th,
Right.
and just talked about renoticing the motion. So what happened with the mediation idea?
I remember speaking with Mr. Horka to get a status update from that date, and he said that the tribunal, I don't remember the exact name, had never heard back from Ms. Giller, had left her multiple messages and maybe even sent an email, if my memory serves me correctly, that she was simply not responding at all to coordinate mediation. And I thought that was addressed at the November hearing where it was the decision of the court. Okay, fine, we will schedule this motion.
And that might have been, my notes might just be deficient on that. Does that sound right,
That's why we're here today.
Does that sound right that we talked about mediation in November and just decided to go forward with the motion?
Yeah.
Okay.
I never heard back from the mediation people. I'm not exactly sure what happened or what he's even talking about because I was never contacted.
All right. So are you willing to go to mediation?
I want to completely be done with this case. I have a lot of stuff all the way down to city documentation. That house was never even registered for somebody to be living in it for the first year that I was there.
Okay. But ma'am, that doesn't answer my question. So we're not going to be done with this case today. So my question is, are you willing to go sit down with a mediator to see if a mediator can help you and Mr. Singh on behalf of Punjab Investments work something out between you to settle this case?
Sure.
All right. So here's what I'm going to do. Counsel, I'm going to order her to amend her complaint within 3 weeks. I don't think there was ever a motion for a more definitive statement. So I'm going to order her to give a amended complaint, file it with the court, that hopefully gives you folks a cause of action so you know exactly what you're defending. If it's still deficient at that point and that item or that issue still fits into your motion for summary disposition, then we'll deal with that at a scheduled notice for the motion. In the meantime, I'll leave it to the parties to contact Wayne County Neighborhood Dispute Resolution and get something set up.
I've just never had to do that before. So this is basically like just the a mediator that's going to sit between the two of us.
It's a mediator because, ma'am, you don't have an attorney involved, and I can't represent you because I'm the judge.
Yeah.
You need to get some advice about the case that you're involved in from somebody that's an objective observer that can talk to you and give you the skinny. Okay. Because if I go forward today and make a decision, I'm going to throw your stuff out because you don't know what you're doing. Bottom line.
Okay. Okay.
You haven't done the paperwork properly, and the fact that you don't have an attorney doesn't mean that the counter plaintiff and defendant doesn't get to exercise his rights under the court rules and statutes.
Right. Okay.
This is where the risk becomes structural. The defendant believes evidence alone carries the case, but civil procedure doesn't work that way. Her confidence in just showing proof feels logical, but legally it collapses. Without proper filings, she's not losing on facts, she's losing access to even argue them.
Okay.
So, either I got to start taking over your case, which I can't do, or you're going to lose because you don't have a clue what you're doing.
Okay.
Now, I don't know if your case has merit or not. I just know that the paperwork that's been submitted to the court doesn't show much for me to work with if I want to find in your favor.
Okay.
Am I making sense?
Yeah.
So if I send you to a mediator, the mediator is going to talk to both sides about their strengths and weaknesses and try to help you to resolve the matter. If you can't resolve it, that's fine. Then you're back to court for me to make a decision. But if I had to make a decision today, you're in trouble.
Okay.
So A, I think the mediator might assist in that, and B, that'll give you some time to try to get the advice of an attorney. So if we do move forward, you at least have the proper paperwork that's been filed in the proper manner.
Okay.
So are we clear on a cause of action or a course of action, counsel?
Yes, can we establish some 100% accurate contact information for the defendant today? Because I will set up the dispute resolution and I want it said exactly how she will be contacted.
Sure. Ms. Giller,
So I
I've got
think
your
I
phone
require
number.
an email.
Yeah, let's start with a phone number. I got you down with 313-932-7286.
Yes.
All right. How about an email? Do you use an email?
Yeah, it's Dawn, DAWN, the letter N, Giller, GILLER, at yahoo.com.
So it's Dawn with an extra N, Giller.
Yes. Yes.
Counsel, did you get that?
I did, but I did not get the phone number. 313-9.
932-7286. So counsel, what I noted in my file that Singh removed from the suit as a result of your motion. The balance of the motion is going to be adjourned to a later date yet to be determined. In the meantime, Ms. Giller's got 3 weeks to file an amended complaint, and the parties are going to set up mediation.
What kind of timeline would you like for us, Your Honor, to get that mediation done?
I have
I think
no
with the
idea how
Dispute
to-
Resolution Center,
Yeah, I have no idea how
Last
this is
time-
right now.
last time it took me a good 90 days from the date of scheduling because they kept having to kick it back. So
Let's do this
nothing
then.
shorter.
I'll set this up for an in-house review, 90 days, so it just doesn't fall through the cracks, with the idea that hopefully we'll hear from you or Ms. Giller between now and then.
All right, and Ms. Giller will receive an email that from no reply at courtinnovations.com, and it'll be subject a message from the Wayne County Dispute Resolution Center. She will be required to go in there and accept the mediation after I create the case in there. And then we will wait, no one knows how much time, and they will assign a mediator who will reach out via email to the parties to pick a date that's mutually agreeable. So that email, check spam folders, whatever, that's where it's coming from.
Okay.
This case never turns on who's right about the property, it turns on who understands the system. The judge removes one defendant immediately, not because of innocence, but because liability wasn't legally established. That's a precision failure, not a factual one. From there, the pattern repeats. The plaintiff brings volume, photos, claims, personal experience, but the court requires structure, causes of action, legal arguments, procedural compliance. Without that, even legitimate complaints become invisible in the eyes of the law. Meanwhile, the opposing side doesn't need to disprove everything. They only need to show that the case, as filed, doesn't meet legal standards. That's a lower burden, and it's why procedural attacks like summary disposition are so powerful. The judge steps in, not to save the case, but to pause its collapse. He gives two lifelines: amend the complaint or resolve it through mediation. But both options require something the plaintiff hasn't demonstrated yet: legal clarity. This is where many sovereign citizen-style misunderstandings surface, the belief that personal truth overrides legal structure. But courts don't operate on personal conviction, they operate on rules. And those rules decide who even gets heard. At this stage, the outcome isn't determined by evidence, it's determined by whether the plaintiff can translate her situation into legally recognizable claims before the system closes in. Because in court, being right isn't enough. You have to prove it the right way.